Hello, thank you for joining for this webinar. Thank you to MBL Seminars for having us. My name's Stephanie Kay and I'm a Legal Director at Clarion, and I'm joined by my colleague Daniel Murray, who is an associate also at Clarion within our Costs and Litigation Funding team. This session is all to do with top tips for avoiding reductions to legal fees. And it's following the landmark decision earlier this year in relation to the case of Kennig, which you're going to be hearing all about. This session is relevant to largely probate solicitors and private client solicitors on the whole, and hopefully you're able to take something away from this session today. In terms of the format today, we thought it'd be useful to outline this. It's going to be around 60 minutes. And the session is aimed at private client lawyers, as I mentioned. So it's purely as a result of this decision, which I think has ruffled a lot of feathers in the industry and made people worry a little bit about the outcome and what this means. You'll be hearing all about that with the relevant case law and statute to go alongside it. Dan has all the fun jobs today of all the technical stuff, and I'm here for the bits around it. We're going to talk through the recent developments and what it actually means practically, so what you can do to avoid those legal reductions, how to avoid finding yourself in that position yourself, and our top tips for avoiding reductions overall. So we're going to come on to those after a real deep dive into the case law and statute surrounding this area.
Who may not be third party when it comes to challenging your bills of costs is really anyone who just volunteers to pay legal costs on behalf of someone, a party who's been ordered to pay a fixed sum in respect of an opposing party's costs. Those are two really the kind of the key examples to who may not legitimately look to challenge your bill of costs. So important to bear that in mind if you were to receive any requests from those types of individuals.